I'm John Malcolm. I'm the director of the Edwin Meese Center for Legal and Judicial Studies. We are here today to discuss a new book entitled Obama's Enforcer, Eric Holder's Justice Department. The book is a thorough, provocative, and unsparing account of the Department of Justice under the tenure of Attorney General Eric Holder. It describes a Justice Department that is suffused with hyperpartisanship and racialism. It describes a department that is preoccupied with imposing its version of racial justice and which has no qualms about bending, ignoring, or breaking laws to suit its purposes, no qualms about attempting to discredit conservatives who served in the prior administration or who still serve at the Department of Justice, and no qualms about covering up its own dirty laundry, such as Operation Fast and Furious. We are fortunate to have with us today the co-authors of this book, Hans von Spakovsky and John Fund, who previously collaborated on Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk, which was published by Encounter Books in 2012. To my immediate left is John Fund, an award-winning journalist who's been referred to as the Tom Paine of the modern congressional reform movement. John is currently the National Affairs columnist for National Review magazine and is a frequent analyst for Fox News Channel. He's the author of several books and a former columnist and member of the editorial board of the Wall Street Journal. To my far left is my friend and colleague Hans von Spakovsky. Hans is a senior legal fellow here at the Meese Center, and he is a former presidential appointee to the Federal Election Commission. Prior to joining the commission in 2006, Hans served as a counsel to the Assistant Attorney General in charge of the Civil Rights Division at the Department of Justice. Please join me in welcoming our panelists.
Thank you all for coming. I'm John Fund. Before we begin, I thought I'd give you an update on the news, which touches on the Justice Department. You probably have heard the story that last Friday the IRS notified Congress it had lost 2 years of Lois Lerner's emails. The dog ate my emails for 2 years. Well, the dog was very hungry because today the IRS quietly told Congress that it has lost the emails of 6 other key players in the IRS scandal, including those of Nicole Flax, who was the chief of staff to the former IRS Commissioner Stephen Miller, who was fired in the wake of the targeting of conservative nonprofit scandal. So clearly this dog has now eaten up 7 employees' emails, and I sure hope they send him to the pound soon, because he is doing untold damage in trying to conduct this investigation. The reason why this touches on the Justice Department, of course, is the Justice Department is in charge of the investigation of the IRS targeting scandal. It has been moving with glacial pace. I can't say they haven't interviewed anyone, but of all the players I know, they haven't gotten to them yet, and it's only been 13 months, so they must be moving with all deliberate speed. In addition, the head of the investigation is Barbara Bosterman, who is a career Justice Department trial attorney, but she's also one of the most important Obama campaign donors. Almost $7,000 to President Obama's re-election and original election campaign, and an original supporter starting all the way back in the primary season of 2008 when Hillary Clinton was the clear front runner. Of course, there is no conflict of interest here, according to the Justice Department, not even, to quote President Obama, a smidgen of evidence that there is a conflict of interest. So I'm not here to directly address the IRS scandal, although that may come up in questions. What I would like to talk about before Hans goes into more detail in our book is a little bit about the record of the Obama administration's rather remarkable expansion of executive power and authority. As you know, every president has the right and the responsibility to exercise his full constitutional powers, to implement his electoral mandate, and to resist encroachment on those powers by the legislature and judicial branches. However, this president has increasingly taken upon himself powers and authority that previous presidents never have, and there are some egregious examples. Back in 2011, President Obama rejected the notion that he, as he put it, quote, "I can just suspend deportations of illegal immigrants through executive order," unquote. As he acknowledged back in 2011, there are laws in the books of Congress, and for me to simply through executive order ignore those congressional mandates would not conform with my appropriate role as president, unquote. That was then, this is now. Congress then refused to enact the DREAM Act, which affected illegal aliens under the age of 18 who had come to this country largely through no fault of their own. Congress's failure to act, the Obama administration then reasoned, justified adoption of the so-called deferred action policy, which does precisely what Congress refused to do when it declined to pass the DREAM Act. It exempted from deportation up to 2 million illegal aliens who were children when they came to the United States. Similarly, the administration has announced it will not enforce immigration laws with respect to illegal aliens who are parents or legal guardians of U.S. citizens. Secondly, the Obama Department of Education effectively amended core requirements of the No Child Left Behind Act by granting states wholesale waivers in return for their agreement to adopt certain education policies established by the department, rather than those established by Congress, which is the lawmaking branch. And lastly, when the Senate refused over an extended period of time to confirm President Obama's nominees to the National Labor Relations Board, President Obama gave all of them temporary appointments under the Recess Appointments Clause, notwithstanding the Senate was meeting every third day in pro forma sessions and therefore was not in recess. President Obama has declared the Senate's pro forma sessions a practice which dated back over 60 years to be a nullity and thus presumed to overrule the Senate's judgment as to when it was in session and when it was in recess. The administration actually made the extraordinary argument before the Supreme Court, which is due to rule on this case in the next week or so, that the Senate could, of course, retain its recess power by just remaining in session continuously, forever. That would be the only remedy that they would have to avoid a recess appointment. This record, extreme positions on the scope of federal power, has generally left even sympathetic judges to a liberal president unimpressed and frankly in opposition. One of the more remarkable distinctions of the Obama administration since 2012 has been the Supreme Court has ruled against the Justice Department's position on key issues approximately a dozen times, depending on how you characterize the decision. At least 10, probably 11, possibly 12. These come in a remarkable series of cases. They involve everything from religious freedom to property rights to Freedom of Information Act requests. It goes down the line. I'll just give you a couple of interesting examples. And again, these are all unanimous defeats by the Department of Justice at the hands of the Supreme Court. Sackett versus the Environmental Protection Agency, the Justice Department tried to prevent a family from defending itself and contesting a ludicrous order from federal bureaucrats. Basically, the EPA directed this family that was trying to build a house in a subdivision in Idaho. It demanded that they cease construction and give the EPA access to it. Failure to comply with this administrative order would subject the Sackett family to a fine of $75,000 a day. Basically, what the Department of Justice was effectively defending was the right to put the Sacketts into a catch-22 situation. Either they complied with the EPA's rules or they faced fines of up to $75,000 a day while waiting for the Environmental Protection Agency to sue and basically denying the Sacketts their day in court. The Supreme Court rejected this 9-0. Then we have the case of U.S. v. Jones. The Justice Department essentially tried to convince the Supreme Court that the Fourth Amendment's protections against search and seizure should not prevent the government from tracking every American at any time without any reason. Believe it or not, Justice went into court and argued that the police should be able to attach a GPS device to your car without a search warrant or even any reason to believe that you had committed a crime or were even about to commit a crime. The Justice Department's arguments fell on deaf ears. Justice Sotomayor, President Obama's own nominee to the court, chastised the Justice Department for, quote, invading privacy interests long afforded and undoubtedly entitled to Fourth Amendment protection, unquote. And I could go on. This is a remarkable record of defeat. In fact, if you look back over the last 2 or 3 terms, the Obama administration's Justice Department has succeeded before the Supreme Court only about 40% of the time. That is compared to an average of over 70% for previous presidents in the last half century. To put that into perspective, they have failed more than twice as often as the Clinton administration and more than 3 times as often as the Bush administration. This is a record that, frankly, does not put them in good stead with the legal community. And I believe in the next couple of weeks, we may see a couple of more unanimous decisions, perhaps even on the recess appointment question, that will come down and further tarnish the Justice Department's record. Now, even liberals are starting to wake to this. Jonathan Turley, who is a very distinguished professor of law at George Washington University, has said he is very concerned that there's a shifting of gravity within our constitutional system in a very dangerous way that makes it unstable. He said, we used to hear a lot of objections when Republican presidents expanded the powers of the executive from the left and from the news media, but they have not been raising the same objections now that we have a Democrat in the White House, and I believe this is happening at our peril. As Turley said, quote, I'm afraid this is beginning to border on a cult of personality for people on the left. Our leader, right or left, seems to be their motto. I happen to agree with many of President Obama's policies, but in our system it is often as important how you do something as what you do. So for that and other reasons, Hans and I wrote this book. It covers a wide range of subjects, everything from Fast and Furious to, yes, the IRS scandal, to the withholding of documents from various congressional investigations, not just the IRS scandal, to the administration's record on national security, business law, a whole range of things. And for some of that, and of course, in preparation for your questions, Hans can pick up the pace now. Thank you.
All right, the real question is, why should you care about this? Well, I'll tell you why. And I say this as a veteran of the Justice Department, where I worked for 4 years. The Justice Department is the most powerful and largest law enforcement agency in the U.S. They can make or break any individual and any business. They can ruin you economically. They can put you in jail. And we should all fear a Justice Department that is politicized, is not pursuing justice the way it should, because that kind of abuse of power is frankly dangerous to our freedom and to our liberty. And I will tell you that one of the people we interviewed for this book, who was hired during the Clinton administration, said to us that Eric Holder is the worst attorney general since Mitchell under Nixon, which to most veterans of the department will tell you they consider to be the nadir of the Justice Department. Now, part of this book is talking about how Eric Holder came to the Justice Department. And while there's been a lot of discussion of his tenure over the past few years, many people forget that he was the #2 guy there during the Clinton administration. And in fact, he was the go-to guy for the White House. Why? Because they didn't just trust Janet Reno to make the right political decisions. But they trusted Eric Holder to do that. And that's the key thing for you to understand here, is that Eric Holder is an ideologue, and he considers himself the president's attorney first, the attorney general second. And that is a very big problem with the attorney general. Now, some will characterize this as a partisan attack. It is not. We have had very good, very ethical, very professional attorney generals in the past under both Democratic and Republican administrations. But I'm afraid if you read this book, you're going to come to the same conclusion we did, that we don't have that with the current attorney general. And I'll give you just one example of how this is not something new with this attorney general, and that is something that happened during the Clinton administration. I'm sure most of you have heard about the Mark Rich pardon, in which he helped engineer a pardon for someone who was an international fugitive, which is, I'm not sure that had ever happened before. You know, the president has the authority, and there's a pardons office at the Justice Department that veterans are familiar with. And yeah, we know about this pardon that was given to someone who had not been arrested, had not stood trial, had not been convicted and was in court, but somebody who had fled the United States abroad after Rich's wife gave a lot of money for building the new Clinton Library. But that's not actually one of the worst things that Eric Holder engineered. One of the worst things that he engineered was another series of pardons for 16 terrorists. There were 16 terrorists of the FALN. This was a Puerto Rican independence group. They had been involved in 130 bombings, armed robberies, 6 killings, and hundreds of injuries in New York, Chicago, and elsewhere. The federal judge who sentenced them said that if the death penalty had been available, he would have given it to them. They were totally unremorseful. In fact, in court, when they were being sentenced, they threatened the judge. They threatened the federal judge who was sentencing them. The career pardon attorney at the Justice Department was against any pardons for them. So were the FBI, prosecutors, victims, and you know what? They hadn't sought pardons. None of the 16 terrorists in federal prison had sought pardons from the Clinton administration. But Eric Holder engineered these pardons. He was all in favor of it. And why? Well, because at the end of the administration, when this was going on, was when Hillary Clinton had started her run for the Senate in New York, and all of these political consultants and others were saying this would help her campaign, it would help her get the Puerto Rican vote. And so Eric Holder was willing to sacrifice national security and the victims of these bombings and killings. Why? For political advantage. Now, we talk about many other areas of the Justice Department, including, for example, the Environmental Division, and we have a whole chapter talking about the Gibson Guitar raid. And I have to tell you that in itself, again, it's just shocking when you read it. You know, Gibson Guitar is a storied American guitar maker, been in business for 100 years. And what happened? The Justice Department treated them like they were a mob organization or a drug cartel. Armed federal agents showed up at their factories and their offices and seized all of their business records, computers, and hundreds of thousands of dollars of wood that they were going to use for fingerboards under the claim that they had illegally imported this wood from Madagascar and India, despite the fact that Gibson Guitar had evidence that, in fact, this wood was perfectly legal in India and Madagascar. But this was something that was urged by the environmental allies of the administration, organizations like Greenpeace and others. And so they get treated, Gibson Guitar, like they are the worst kinds of criminals. Now, this case went on, and in the end, the Justice Department entered into what they call a deferred prosecution agreement. I can tell you that when the Justice Department enters into what they call a deferred prosecution agreement, it's because they don't have the evidence to go to trial and convict. And in fact, it's very clear that they didn't have the evidence to convict in this case, because as part of this agreement, they agreed to give back all of the wood they had seized. And they said that they wouldn't, in the future, prevent them from importing it. Now, what was interesting about this case was that at one point the Justice Department seized all this wood from a supplier. And this supplier supplies this wood not just to Gibson's Guitar, but to other guitar makers. But Gibson's Guitar is the only guitar maker who's the head of the organization is a prominent conservative who's very outspoken about it. The other guitar makers who received the same wood weren't the object of this kind of a prosecution. Now, the contempt for the Constitution and the rule of law is quite something. John has gone over that. And the only thing I want to say about that is that you are taking an extreme legal position when all 9 justices of the Supreme Court disagree with you, including your former Solicitor General. And yet we have a dozen cases like that, and the Solicitor General going from almost always winning their cases to losing most of their cases. That is a sign of how extreme the legal positions are that the department is taking. We've got a whole chapter about the Civil Rights Division where I used to work. We call it the Uncivil Rights Division. And this isn't just based on our opinions, but it's also based on an Inspector General report that was released last year and got almost no media attention. And it goes through and it describes everything, including perjury committed by employees of the Civil Rights Division. Or, for example, a case in which a Louisiana federal district court judge castigated members of the division, lawyers in the division, and folks in the U.S. Attorney's Office down there for engaging in behavior that was so bad that he notified the bar associations about it. And what were they doing? Well, for example, one of the lawyers in the Civil Rights Division was making anonymous postings to the Times-Picayune news site. This is the main newspaper down there. And what was she doing? She was making anonymous postings that attacked the defendants in a case that the Civil Rights Division was prosecuting, attacked the defendants' lawyers, and in fact, the attorney who was doing it, she was what's called the taint attorney. Some of you may know who are lawyers that, when a police officer is involved in some kind of scrape or something else, they have to talk to internal affairs. And when they're talking to internal affairs, who's investigating this, they cannot assert the Fifth Amendment. They have to answer the questions. And so the rule is, and this has been established by the courts, that whatever information they give to internal affairs investigators cannot then be used in a prosecution later against them because they couldn't assert their Fifth Amendment. This particular lawyer at the Civil Rights Division was the taint attorney. Her job was to protect the rights of the defendants being prosecuted and to make sure that the prosecution team didn't use any of that tainted evidence that they were unable to use, and yet she was putting up anonymous postings attacking the defendants who she's supposed to protect and their lawyers. And she still works at the Civil Rights Division today. And this Inspector General's report in our book is filled with other folks too, doing all kinds of anonymous postings, including a woman who, when the Inspector General was investigating this, lied about it to the Inspector General investigators. And the only reason she finally admitted that she had been making anonymous postings, which included, by the way, confidential legal information, was because the investigators confronted her with the email evidence. See, they were actually able to find it, unlike the IRS. And you know what her reaction was? Her only regret was that she'd been caught. And this woman was not disciplined for this breach of ethics and professional duties. She wasn't terminated. She still works in the Civil Rights Division today, and she's been treated as a hero. Why? Well, because her anonymous postings attacked conservatives and any people working in the division who were perceived to be conservatives. Now, we also talk about the Pigford scam, which was a settlement that particularly Pigford 2, which is a settlement that was engineered by the Holder Justice Department and the White House, which was simply the biggest political payoff in American history, using taxpayer funds to buy the votes of members of particular minority groups. A member of the Department of Agriculture called it the largest scam against federal taxpayers in the history of the United States. And in the settlement of this case, there was actually a meeting at the White House run by the political people in which members of the Justice Department, the prosecutors, actually came over and who said, we're going to win this case because there's nothing to it. It's a frivolous case. Even the own experts hired by the Justice Department said there's nothing to it. And the White House said, no, we're settling this case and we're paying all these people off. Holder has on numerous occasions misled Congress. He has on numerous occasions said, I don't know, when asked questions about key issues. And I could tell you, something important about that from my own experience. Okay, when I was at the Justice Department, part of my job was preparing my boss to go testify in front of Congress. And we would have a whole team of people who would put together elaborate briefing books with a 1 or 2 page briefing paper on every single question we could think of that our boss would get asked about. And then we would have what was, well, affectionately, not so affectionately called at the Justice Department, murder boards, in which we would bring our boss in, and all of us, and John used to work at the Justice Department, and he participated in this kind of thing too. The lawyers who had prepared all the briefings, we would get to play our favorite senators and members of Congress and our unfavorite members of the Senate and Congress. And we would ask questions of our boss who was going to go up and testify. And I can tell you there was never a single question in a real hearing that we had not anticipated getting, and that we were not able to prepare our boss to be able to answer. So I can tell you that when the Attorney General is constantly saying, I don't know, in answer to question after question after question from members of Congress about key issues and key cases, well, you got 2 choices. Okay, one, he frankly just has a contemptuous and dismissive attitude towards Congress, doesn't care about their constitutional oversight function and responsibility, and he just doesn't want to answer. Or he has a totally incompetent staff who isn't preparing him right. Well, I've worked with people at the Justice Department. The staff, particularly the highest reaches, is not usually incompetent. So, but I'll leave it up to you as to choose which of those 2 is going on there. We also cover national security. There's so much to say there. I will just tell you a couple things. One is that he has moved the Justice Department back to the criminal model of dealing with terrorism that was such a failure during the Clinton administration. And he has, by the way, opened up more leak investigations of classified information than any prior Attorney General combined. But those leak investigations have a very interesting pattern, which is that when they're able to find and prosecute low-level individuals, they do so. But all of the leaks that have clearly and obviously come out of the White House have come out of high-up political appointees. Everything from all of the dangerous release of information that came out after the killing of Osama bin Laden, identifying SEAL Team 6 as being involved in it, putting their families, they're stationed in Norfolk, putting their families and putting them in danger, to the release of information about the Stuxnet virus, which is the virus that we very successfully inserted in Iran to slow down their production of a nuclear bomb. All of those leaks, the Justice Department doesn't go after the people who do that. All of the leaks that were deliberately engineered by the White House to make the president look good, to make him look tough, Eric Holder has no interest in doing that. And there's a great story out of that about the fact that, our former Secretary of Defense, Robert Gates, was so concerned over the leaks coming out of the White House about these kind of issues that he requested a meeting with Tom Donilon, the National Security Advisor, saying he wanted to have a meeting about, quote, new strategic communications approach to communications. And he went to the White House, got into the meeting room, and Donilon said, whoa, what is this great new strategic approach you have to communications? And Robert Gates leaned over and looked at him and said, shut the blank up. Now, what's to be done about this? Well, I'll tell you, it's very difficult to do anything about this. Eric Holder and his subordinates have politicized the Justice Department to a degree that I have never seen before. In fact, we talked to a current employee who she was talking, this person in particular was talking about one of the other divisions, but this really applies to the whole Justice Department. And this lawyer said that they have racialized and radicalized to the department to the point of corruption. They have embedded politically leftist extremists in the career ranks who have an agenda that does not comport with equal protection or the rule of law, who believe that the end justifies the means, and who behave unprofessionally and unethically. Their policy is to intimidate and threaten employees who do not agree with their politics, and even moderate Democrats have left the department because they were treated as enemies by administration officials and their lackeys. The only way to do anything about this is through new leadership. You need an ethical attorney general, and those get chosen only by the president. And until we get a new attorney general in who's willing to bring the standards of the department back up as prior attorney generals of both political parties have done, nothing is going to happen to clean up the department. In fact, you're going to continue to have the department, and particularly Eric Holder, advising the president that he can break the law, ignore the law, change the law, as he did just last week. You all may know, just a week ago, Eric Holder announced that he's going to provide legal representation, lawyers and paralegals, for young illegal aliens who are in the country. Now, you can argue about whether or not that is the right thing to do from a public policy standpoint. But he's the Attorney General. He's supposed to abide by the law. There's a provision in the federal immigration law that prohibits that. So he cannot do that under the law. And yet he blithely says, I'm going to do that. We're going to provide the money to do that, despite the fact that federal law says you cannot do that. And that is just another example of the lawlessness that pervades the Justice Department these days. Thanks.
I'm sure that many of you have comments and questions. Do we have we do have microphones in the room, so I will recognize people. I just have a few ground rules. One is, please wait till you have the microphone. 2, announce your affiliation. 3, keep your remarks short. And 4, end them with a question mark. With that, I will go to over here to Todd. Let's microphone over here. Here we go. Great.
Todd Gaziano. I'm now the executive director of the PLF's new DC Center, but I've been a longtime colleague of John's and Hans and want to congratulate him and John. But I do want you to comment on one thing that I don't think either of you hit, but was certainly implied, that's also implied in the title, and that is, how could someone like Holder survive these serial scandals? And that's because he's doing Obama's bidding. And I do disagree with you, and I'll end with a question. I could talk about Perez's perjury before a certain civil rights commission, and he was not just kept in place, he was promoted, even when that perjury was exposed. So I disagree that nothing can be done until the next election. I think that what your book is doing is great, and so why don't you talk more about exposing the responsibility that goes even higher than the Attorney General?
Well, I should say we do that in the book. I mean, the president has exactly the Attorney General he wants. Look, it's not that I'm. I mean, you have to be careful with this parallel, but I mean, the parallel is that, look, Eric Holder is a lot like a mob lawyer who tells his boss exactly what he needs to be able to do whatever he wants. And that's the way this relationship works. What Mr. Gaziano is talking about with regard to perjury is the fact that one of the things we cover in the book is that you all may recall that when the new Black Panther voter intimidation case was dismissed by this Justice Department, there was testimony under oath before the U.S. Commission on Civil Rights by the head of the Civil Rights Division, Tom Perez, saying that this decision was made entirely by career civil service lawyers, political appointees, had nothing to do with it. Turned out that was completely untrue, and That's not me saying it, that's a federal judge saying it. Because Judicial Watch filed a Freedom of Information Act request to get all internal communications of the Justice Department about this dismissal. And when that ended up before a federal judge here in the District of Columbia, and the District of Columbia judge ordered the release of some of those communications, the judge said that those communications demonstrated that, in fact, the claim that political appointees were not involved in the dismissal was untrue. And so this individual, Tom Perez, who was the head Assistant Attorney General of Civil Rights, who clearly had lied under oath to the U.S. Commission on Civil Rights, was then nominated by the President to be the head of the Labor Secretary and was confirmed. So he was basically rewarded for that behavior.
In addition, Mr. Perez, while he was at the Civil Rights Division, had conducted government business extensively on a personal computer at home, which is against all guidelines and all rules for federal government workers. He had discussed policy prescriptions. He had discussed settlements, which were highly controversial. And the Justice Department admitted this had been done. They admitted that there were hundreds and hundreds of these instances. And in fact, they have occasionally acted against this recurring habit of political appointees in the Obama administration from conducting government business sort of off of the books. Lisa Jackson, the Environmental Protection Agency administrator, she left rather suddenly and precipitously, in part because it was discovered that she was conducting extensive government business using an alias, Richard Windsor, for much of her work. Richard Windsor apparently was an amalgamation of a town she had worked in and her dog's name. So they've occasionally been interested in this, but when it comes to key players who offer them legal advice and that they rely upon, they ignore this. Mr. Perez was nominated to be Secretary of Labor despite these glaring violations of ethical standards and norms.
Other questions? Over here. Yeah.
Hi, I'm Deborah Weiss from Front Page Magazine. And my question is, as you know, we finally have a select committee for the Benghazi incident. But if they find wrongdoing by high-up political officials in this administration, a finding of something wrong isn't really helpful unless it can be prosecuted. And I assume it's DOJ that would be the one that has to do that. And doesn't sound like it would happen from what you're saying. Do you have any comment on how you see that playing out?
Well, the Department of Justice's record of following prosecutorial standards is rather indifferent. You might remember that the House of Representatives actually censured the Attorney General, the first time that's ever happened in history, for refusing to turn over documents in the Fast and Furious gun running scandal, which was an appalling misuse of department resources. It resulted in the death of a U.S. border agent and hundreds of Mexican nationals. And those documents are still being withheld to this day. They're the subject of litigation. Well, the statutes say that when Congress censures an administration official, that has to be transmitted to the U.S. Attorney for the District of Columbia. And that then the U.S. Attorney of the District of Columbia has to make a determination as to what to do about that. That was never transmitted. It's blatantly against the law. The Department of Justice not only disagreed with what Congress had done to censure, or the House had done to censure Attorney General Holder, they refused to comply with the law, effectively giving the middle finger to Congress and its constitutional ability to confront the executive branch.
Other questions? Down here.
Thank you. Peggy Orchowski, I'm the congressional correspondent with the Hispanic Outlook magazine. And 2 quick questions. What do you know about Jay Johnson, and how did he get the position as Secretary of Homeland Security? What's his connection with the Department of Justice? And the other is, Eric Holder keeps saying he's going to leave. Do you have any idea who might be in line to replace him?
Well, I can address the second part of that question. He's not leaving.
Okay.
I mean, I think he's the safest job in America. For one thing, the president wants him. For another thing, he's done with whenever there's a fork in the road, where the Attorney General has a delicate position. He is the president's appointee, which means he certainly wants to and should follow the president's prosecutorial emphasis and his priorities, and every Justice Department is free to emphasize its own priorities, but he also has to uphold the rule of law. And whether it's Griffin Bell or Ben Civiletti under Democratic presidents, or whether it's Ed Meese and Richard Thornburg under Republican presidents, attorneys general have found a way to straddle that delicate balance. In the case of Attorney General Holder, every time there's been a fork in the road and there are political priorities that must be met and that there's the rule of law, he has gone in the direction of the political priorities. Should he leave the office of Attorney General before President Obama's term is up, he would be subject to all kinds of subpoenas that he would have to answer as a private citizen, all kinds of court appearances that he would have to answer as a private citizen, all kinds of requests for documents he could no longer stonewall or count on stonewalling, and he basically, his new job title would be permanent witness. So I don't think he wants that. So he will be Attorney General, I can almost assuredly predict, until noon of January 20th, 2017.
Other questions?
Johnson, you know.
Our book is on the Justice Department.
Yeah, so I can't really answer questions about it.
Didn't he come out of the Justice?
I don't believe so.
Hi, David L Massey with the National Center for Public Policy Research. Hans, you mentioned briefly about politicos embedded within the Justice Department.
Right.
This was a big scandal with the Bush administration, that they were hiring people on a political basis. How has the Holder Justice Department been about hiring political appointees into career positions?
Well, they make the Bush administration look like amateurs. Well, like if you look in the Inspector General report, it's not just politicos, but it's hiring from advocacy organizations. And so, for example, if you look at the Inspector General report that was released last year, you'll find that in the Civil Rights Division's voting section, the majority of the lawyers there have all been hired from just 5 advocacy organizations. You know, the Mexican American Legal Defense Fund, La Raza, the ACLU. So those folks, I can tell you from experience with them and from people we talk to, they don't make the transition to being government lawyers. Because when you leave private practice or you leave an organization like that and you go to work for the Justice Department, you have to transition into being a government lawyer whose job it is to represent the public as a whole. And I can tell you the people that have come from those organizations, they just now think they're still working for those organizations, but they have the government's power and the government's resources to do what they want. But you know, we did Christian Adams and I a couple of years ago, and we talk a little bit about this in this book. You know, we did a FOIA request for the resumes of all the career people that have been hired into the Civil Rights Division since the start of the administration. And 100% of the people hired were clearly hired on the basis of their politics and their ideology. And in fact, the Inspector General's report, if you look at it, it has this whole paragraph where it talks about how in the hiring process, the Civil Rights Division clearly overlooked and didn't hire lawyers with stellar credentials from disfavored organizations and firms.
Hans, I'll get to another question in just a second. One of the things that you talk, both of you actually, that you talk about in the book had to do with the Department of Justice's role during the Bush administration in terms of providing legal advice regarding the conduct of war and detainees. Right. Obviously very politically controversial, and the role that Eric Holder played and the Office of Professional Responsibility played with respect to the investigations of John Yoo, Jay Bybee, and others. Can you talk just for a few minutes about that?
Yeah, I mean, and this really shows how politics drives the Attorney General, not the law. Look, there was a great deal of controversy over the techniques used by, for example, CIA interrogators and others in trying to get information out of the terrorists housed in Guantanamo Bay. But you know, at the end of the Bush administration, the Justice Department set up a team of prosecutors, career prosecutors, not political appointees, to take a look at all of the actions that the interrogators and others had taken, and they had done it according to legal memos issued by the Justice Department, but they took a look at all the actions that these interrogators had done to see if any of them had violated criminal laws and should be prosecuted. And with the exception of one contractor, not even an employee, they concluded that, in fact, there was no prosecutions to be had. They had followed the law. Now, when Eric Holder came in, what does he do? He reopens that entire investigation to relook again at those CIA operatives to see if they had violated the law. And he admitted in testimony before Congress that he did it without reading the extensive memos that the career lawyers had put into the files on this. I can tell you, John can tell you, because we've all worked there, they wrote extensive legal memos on each of the individuals they looked at, saying, here are the facts, here's the applicable law, here's our recommendation as to what to do about it. And yet he reopens these investigations without reading any of the legal memos that have been prepared by these prior prosecutors, which meant that once again for 2 years, these CIA employees had to hire lawyers, were put through the ringer again of an investigation, and at the end of all of that, they decided, well, gosh, looks like the first people who looked at this were right. After putting these CIA folks who were working as hard as they could to protect all of us through what was a completely unneeded nightmare all over again.
You know, there was a famous poem about prosecutorial abuse written in the 1960s by a fellow named P.W. Grant. It's called The Incredible Bread Machine. Bill Gates was so taken with this during the Microsoft prosecution in the 1990s, he printed 100,000 copies to distribute to all of his employees. In the poem, there's a final scene in which the entrepreneur who's being persecuted is dragged before the court for sentencing, and he's asked if he wants to make a final statement. He says, I just have one question, why is this being done to me? And the judge looks down upon him and says, in complex times, the rule of law has proved itself deficient. We much prefer the rule of men. It's vastly more efficient. And sadly, that's the kind of Justice Department we're heading towards. The rule of law, which is the cornerstone of our liberties, our freedoms, and our constitutional system, is increasingly being eroded for the sake of political convenience and the sake of personal agendas. And it's very sad, because I can assure you, it's very difficult to build the rule of law. It's very easy for it to become the rule of men. Once it's the rule of men, it's extremely difficult to walk that back. It is possible. We've seen the Justice Department restored after Richard Nixon's depredations and John Mitchell's depredations, but it requires an awful lot of effort, and this is something that we all have to pay attention to, because there will be much reclamation work to do in future years.
Back there.
I'm Joel Mandelman. I'm involved in representing some of the Amici and Johnson versus the Office of Personnel Management. I have two questions. First, there's a new administration in 2017. I suppose it's one of us. What opportunity is there for a new Attorney General to clean house under current civil service laws and get rid of all of these racialists and other people that were hired improperly? Does this require new legislation? Can the Attorney General just announce we're firing 150 or 200 people that have misused their career attorneys who've misused their authority? And second, specifically, I don't know if it's covered in the book, what, if anything, was done to discipline the attorneys who were responsible for trying to frame Senator Ted Stevens and were so castigated by the judge for illegally withholding exculpatory evidence that probably would have led to his acquittal in the first instance?
Well, I'll tell you, it'll be very difficult, because once you get into a career slot, even if you've been put into it in a way you shouldn't have been, it's very difficult to get rid of folks. And in fact, one of the things we talk about is the fact that, and this is, once again, out of the Inspector General report, you know, right at the end of the Clinton administration, there were all these positions open in the Civil Rights Division. These were career slots. And when the U.S. Supreme Court issued its final decision in Bush v. Gore, and the Clinton folks knew that Al Gore was not coming in as president, the political folks in the division said, we have to fill all those career positions before Inauguration Day on January 20th. And they basically, in a federal government that normally takes, if you're fast, 6 months to advertise and fill a position, it can take anywhere up to a year usually, they got every single slot except one filled in 3 weeks. And the personnel folks there, the career personnel folks, said they had never seen anything like this. Now, this administration has basically taken that and gone exponentially further. And so they have filled every single career slot with someone who is ideologically and politically an ally with them, and those are the people who are going to be there when a new administration comes in, and if it's a Republican administration, they're going to have an extremely difficult time.
Other questions?
Ted Stevens.
Now, we don't cover the Ted Stevens issue. Look, we ran out of room. In fact, listen, when we sent the manuscript off to the publisher, and every single day something else would come up that the Justice Department was doing wrong or screwing up, and I kept saying, God, we got to get that into the book. But we just had to call an end to it, and we just couldn't get everything into there.
In fairness, I think Ted Stevens happened on Bush's watch, actually.
It did. So this may just be volume 1.
Other questions? Any closing thoughts from our panelists?
Just that the media's responsibility in letting this happen cannot go unnoticed. This is the media that gave round-the-clock coverage to the relatively non-controversial dismissal of a few U.S. attorneys in the second Bush term for simply not carrying out the president's priorities, which is something that the president has a right to expect. Some U.S. attorneys had not carried out the president's wishes. They served out the entire first term, and then at the beginning of the second term, they were let go and replaced by others, which is a common occurrence. Bill Clinton fired every U.S. attorney in the United States, all 93 of them, the day he took office in 1993, regardless of what cases were pending, regardless of what record they had, regardless of their success rate. He fired every single one of them. It was his right. Bush tries to replace a few, it becomes the cause célèbre, the scandal du jour. For the news media to so extensively cover that, frankly, mountain out of a molehill, and then to allow this record to basically go as it has, with precious little comment. I mean, I'll give you an example. The IRS leak story broke on Friday. The Friday document done. It was only late yesterday afternoon the New York Times ran the first word on this. It took 72 hours for the newspaper supposedly of record in the United States to even mention the IRS email scandal. I mean, where can you go from here? ABC and NBC News have yet to mention it as far as I know. Have yet to mention it. I think that the fact that there's an alternative media out there now, there are internet outlets, there are cable outlets, there are other outlets that where some of these stories can be explored in depth is perhaps one of our few salvations. I think it's incumbent upon all of us to take responsibility for this as well, to tell our friends, our relatives, our neighbors, your liberties are in jeopardy. When an administration could go into court, and I didn't even mention the time in which they said a book could be censured. Remember that case? They literally marched to the Supreme Court and said, yes, we can censure books if we wish to. That's within our power. For the administration to march into court and say, we want the power to put a GPS tracking device on your vehicle, even if you've not committed a crime without a court warrant or search warrant, This is frightening stuff. This is not the government our founding fathers bequeathed to us. And I think all of us have a personal responsibility to tell our friends, neighbors, and relatives our civil liberties are in jeopardy, and we have to pay attention.
Hans?
The one thing I would say is, I don't care whether you're a liberal, a conservative, or a moderate. You should be concerned about this. And if, for example, you're a liberal and you like the policy outcomes you're seeing, you should understand that those policy outcomes are being driven by an attorney general who is basically not following a law passed by Congress and signed by a prior president. And if Eric Holder can do that,
Yes.
and can get the kind of policy outcomes you as a liberal want, well, you know, that means that when a Republican president comes in and appoints a Republican attorney general, perhaps he also will take that as a lesson and not enforce laws that you now like, or take actions which you don't like the public policy outcomes. That's what happens when you have a Justice Department that is not anchored in the law. You know, it's the job of Congress to change the law in a way that you like and others like. They're the ones who are supposed to have that public policy debate along with the president. It's not the Attorney General's job, and he doesn't have the authority to basically veto, have a one-man or one-woman veto in the future of laws passed by Congress, by the popularly elected representatives of the American people, and signed into law by the president. It is extremely dangerous, and it is a threat to our liberty. I said at the beginning, and I will end with that. I worked at the Justice Department. I can tell you, it's very easy to abuse your authority and abuse your power and get away with it. And you do not want people like that working in the Justice Department, and you do not want an Attorney General who approves of that kind of behavior.
Regardless of party.
Regardless of party.
Well, I want to thank you all for coming here, and please join me in thanking our panelists.